morning, everybody. Thank you so much for joining us today. In this session, we're talking about Queensland bylaws and enforcement of those bylaws. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm your host for this webinar, and today we're delighted to welcome back Todd Garsden from Mahoneys. In the realm of strata living, bylaws come in all shapes and sizes. Some body corporate communities have unique, tailor-made bylaws, while others rely on house rules to keep things in order. But can house rules be enforced the same as bylaws? And how do you separate invalid bylaws from valid bylaws? What's the use of having bylaws if they've left to gather dust on the shelf, unenforced and forgotten? Before we begin, I'd like to mention that the information in the session today, including the discussions that arise from submitted questions and also chat conversations, is not legal advice and should not be relied upon as advice. And you should seek independent advice before acting on the information contained in this session. And we welcome back Todd Garsden from Mahoneys. Todd is an experienced property lawyer who heads up the Mahoneys body corporate team. He specialises in body corporate law and predominantly acts for body corporate managers and lot owners on all matters affecting bodies corporate. Todd is an active member of SCA Queensland. In 2019, he was appointed to the SCA Queensland Legislation Committee and assisted in making submissions on behalf of SCA Queensland on issues such as legislative reform in body corporate law. Todd is also a body corporate committee member and he understands the day-to-day requirements of administering a body corporate. He has a focus on achieving practical and commercial results for his clients and understands the market in which bodies corporate operate. Todd is a LookUpStrata regular. He provides responses to our Queensland audience's body corporate questions and has presented a number of webinars with us, and we'll send some links out to those later today if you haven't caught them all, and you will have seen his excellent content in our newsletters and magazines regularly. So thanks, Todd, very much for joining us today for this session.
Thanks very much, Nikki. Morning, everyone. So as Nikki alluded to, today is all about bylaws, where, what, why. Bylaws obviously been something commonly discussed on the LookUpStrata website. So we thought we'd narrow it down a little bit more focused upon those common and more regular questions, not necessarily the normal bylaw content that we've published in the last 12 months. So I think if we go straight to basics and start right at the beginning, what are the bylaws? So the bylaws are basically Schedule C of the Community Management Statement, and that Community Management Statement document will look like what's on the left there. So that's the first page. It's got 5 schedules, A through to E, and the bylaws basically make up Schedule C. So you can sort of see A, B, C, D, E here, and we're looking at Schedule C for bylaws. So if you don't have a copy, easiest way is always to just ask your body corporate manager. They'll have it on file pretty readily and would normally be able to send it to you fairly quickly. Some body corporate managers have portals as well where you can log in and access it. So through an app or through a website, you can go in and search the body corporate record or make a formal request, or you can do a formal search, the titles office, and there'll normally be an agent who charges a fee. It's around about $100 to get a copy. The trick, I think, is important is the CMS changes from time to time. So the copy you were given when you bought a couple of years ago might not be the current bylaws or the current copy of the CMS. So it's always good to check before you start running down based on what the current bylaws are, because they might have changed before you got that copy. And really the only way to check you have the current bylaws is to do the titles office search. So there's a few misconceptions I think are important to address at the beginning. Just because a bylaw has been registered and in the document that the titles office has does not mean that it's valid, lawful or enforceable. There's a number of sections in the legislation which we get through later on which limit and what bylaws can say and give some parameters about what they can do. And once a bylaw is outside those parameters, it can be recorded, but you can't actually enforce it. So there's not much utility in a bylaw that's invalid. Another key point that I think gets missed quite a lot is that bylaws are there to be enforced, and they're to be enforced by the body corporate through the committee against owners and occupiers who breach the bylaws. So they regulate conduct primarily. What bylaws are not designed to do and what they can't is that they regulate the body corporate. So you'll see some bylaws that try and dictate obligations on what the body corporate must do in looking after the scheme. So bylaws don't have that power. That's what the legislation does. There'll be a lot of other bylaws, usually in some older schemes, which try and grant additional powers to the committee, or try and act as disclosure for certain issues to owners. So bylaws can't give additional powers to committee. That's only legislation can give powers. Some of that's a bit of a legacy issue from prior legislation before the BCCMA, which you could actually grant additional powers. And then obviously disclosure issues, that's not what bylaws can do. You can't enforce disclosure against someone. As they're there to be enforced, there is a specific process to do so. And that's a step-by-step process. It does work if you follow the process. So a lot of the time we'll see attempted bylaw enforcement, but those attempts have come up short because they've tried to shortcut it and go straight to a resolution rather than going through the prescribed process. And the last slide of today has a flowchart that the Commissioner's Office has prepared, which sets out this process, which is really handy. And then I think the last point, which has really come to light recently in some adjudication decisions, is that there's a positive obligation on committees to enforce bylaws. It's not an option. It is an obligation in the legislation to enforce bylaws. A really common distinction or concept is what house rules are. So house rules are the rules that the committee makes about how common property is regulated. So the only enforceable rules are the bylaws if they're valid. And they're the ones that are in the CMS, they're approved at general meeting by special resolution, and they're recorded in the Titles Office. So it's a bit of a higher threshold. House rules are not enforceable. They're rules that the caretaker or the committee make informally, even if they pass a resolution, and then they can circulate them around. So they're not recorded anywhere, and really all they act as is guidelines. And there's nothing wrong with having house rules as guidelines, but you can't do too much with it. More just sort of policy statements. So a really common way that I think some lawyers thought they could get around this distinction was to put in the bylaws the ability or the power of committee to go and make their own house rules, because then there's an argument to say that, well, no, house rules are in the bylaws. But as we sort of discussed in the last slide, the bylaws can't give the committee additional powers. So a bylaw that tries to give the committee the power to make its own rules is invalid. And there's an extract of a decision there that I've quoted a number of times over the years to sort of drive this point home. So I think this will be sent out to everyone after if they wanted to save that somewhere. One of the key questions that Nikki and I put together for this is, why are there so many differences between different schemes and different bylaws? And it's a bit of a complicated answer to a simple question, I suppose. Basically, the bylaws for any scheme start when the scheme is recorded, and that scheme is recorded by the developer. So it's drafted before the body corporate comes into existence, before there's any committees, before there's even any owners. It's all done by the original owner and the developer. Now, that developer can pick and choose effectively whatever they want to go in the bylaws. They could even choose not to have bylaws and then just adopt the default bylaws in the Act. The only requirements really on what the developer puts in is what council asks them to put in, and that might not be much. So where those bylaws originate from is if the developer does a lot of developments, they might have their own template, and obviously their template would probably adjust and change over time from development to development. The developer might be engaging a lawyer or a development lawyer to draft that first CMS and the first set of bylaws. So then you'll be looking at your developer lawyer's template CMS, and that would probably change over time as well. So if you had a developer lawyer in 2015 put together a development, and the same developer lawyer put together the development now, there's probably going to be differences between those two bylaws, even though it could be almost an identical development with the same parties involved. What bylaws should be different is based on the facilities and structure. So, if you've got a scheme with a pool, it should have a pool bylaw. If it doesn't have a pool, it shouldn't have a pool bylaw, but we obviously see the opposite quite a lot. And then obviously from time to time, which we might be seeing quite shortly, some legislative changes which trigger bylaw changes. So we might be getting some smoking or pet bylaw changes in the near future. So there's obviously templates and precedents that act as a starting point, but as they change over time, they're really not thought about too much. They're just sort of cherry picked. So one developer might see another bylaw that they like the wording of from another development and copy and paste it into their model set, and then that template just grows and grows and grows, and it's just really a consolidation of any possible bylaw that a developer or developer's lawyer comes up with. The issue, I suppose, with that is what those bylaws start as is the pre-development bylaws, and what meets the requirements of the Act do not always line up. So I guess there's a little bit of a distinction in the industry between pre-development lawyers or pre-development work and post-development work and post-development lawyers. So obviously a lot of what we do is post-development after the scheme's established is checking the bylaws are correct and valid and fixing them, whereas the developer lawyers don't typically do that type of work. Some do and some don't. So there's really quite a distinction between bad bylaws that are cherry-picked over time, and then they sort of get cleaned up by post-development lawyers who are a little bit more invested in the outcome of the scheme once there's a committee involved. So that's my theory on why there's so many different bylaws. What makes a bylaw valid is really distilled into two sections of the BCCMA, and that's 169 and 180. 169 says what bylaws can say, and then 180 says what bylaws can't say, and you've got to try and fit somewhere in the middle. So the key point about 169 is that it says bylaws are to regulate conduct. Now, what adjudicators have interpreted that to say is that regulating conduct is not prohibiting conduct, and regulating conduct allows something to take place. So a very mundane example I've got there is that an owner or occupier must not keep a pet in their lot. So we all probably know at this point that's an invalid bylaw. Everyone knows you can't have a no pets bylaw, but the reason you can't have that no pets bylaw is because that bylaw prohibits it. So the way around it, to make it regulatory and contemplating something taking place, is those words in italics, without body corporate approval. So you'll see in a lot of bylaws, there's a general position that someone can't do something unless they go and get body corporate approval. And a lot of the time, that's the distinction between a valid bylaw and an invalid bylaw. So then we look at section 180. We make sure that the bylaw is allowing a particular type of conduct to take place. And then we go through these sections to make sure that it's not offending them. So first one's a little bit of a catch-all that says that a bylaw can't be consistent with the Act or the module. So obviously, bylaws don't overrule legislation. Legislation overrules bylaws. So some really common examples of bylaws that would offend this section is the body corporate can enter a lot within 3 days' notice, whereas we know that the Act says 7 days' notice unless there's an emergency. So that's one that we commonly come across that is invalid and really shouldn't be there because the right is in the Act anyway. And I'd be preferring to rely on a right in legislation than the bylaws. Second example we've got there is a lot. If a lot can be used for residential purposes, the bylaws cannot restrict the type of residential use. So this is a really common one that gets talked about a lot. Obviously, Airbnb short-term letting is a big issue in bodies corporate, but you can't stop that or regulate it or interfere with it or restrict it because of this subsection. So very, very common way that a bylaw becomes invalid. This third example, so a bylaw cannot prevent a transmission, transfer, mortgage, or other dealing with a lot. So when someone owns property in Queensland, it's considered quite a high right. A fundamental right of the owner is to deal with that property in a way that they want. So that includes selling it, includes leasing it out, includes taking out mortgages, all that type of thing. So that's an inherent right that a property owner has to deal with their property. So the bylaws can't interfere with that. And then the last couple, so bylaw must not discriminate between types of occupiers. So occupiers defined in the legislation to include anyone who occupies a lot. So that can be owner occupiers, it can be tenants. A lot of those rights that are given to occupiers does not make the distinction between owners and tenants. So you can't have a bylaw that is reserved, reserves facilities for owners only and excludes tenants and things like that. So that's a common example we've seen that offends that section. This next one is very, very common. I'd suspect if your bylaws haven't been reviewed, you would probably be able to find one that contravenes this subsection, which is that it imposes a monetary liability. So any bylaw cannot suggest or provide for a cost to an owner. So a really common one is that an owner must reimburse the body corporate for costs that they incur in breaching the bylaws. So it's a no-brainer. It's completely invalid. Unfortunately, the cost of the body corporate enforcing bylaws is the price of doing business. It's a statutory function and obligation. So the costs incurred for it just have to be incurred by the body corporate. The final one is the catch-all. Bylaw must not be oppressive or unreasonable. So when it doesn't fall into the other ones, but you've got a bad feeling about it, this is the one you want to be looking at. So a lot of disputes that end up in the Commissioner's office really discuss what's oppressive and unreasonable. It's quite obviously a general catch-all provision. So a lot of it can be on gut feeling and precedents and things that have happened, and a lot of it's very circumstantial. So it's all depending on the circumstances. One application of that restriction might not apply across all schemes. The last two don't come into it as often, but just sort of included them to cover off on everything. But you can't have a bylaw which is contrary to that very specific part of the Building Act. And what that part of the Building Act provides for is that lot owners wanting to make improvements to their lot or the common property and doing it in an energy efficient way. So you can't reject an application from a lot owner, or can't have a bylaw that provides the committee can reject a lot owner who wants to install windows just because they're energy efficient or the house is oriented in the right way or floor area or minimum bathroom requirements. So they're all sort of covenant type energy saving issues that the BCCMA says that bylaws can't interfere with. And then finally, obviously, you can't interfere with the rights of a person with a disability who has an assistance dog. So that one's quite well documented. So I think more of a practical question here is how do you actually draft and prepare new bylaws to make sure that firstly, they're valid, secondly, they're enforceable, and then thirdly, how you can enforce them. So to me, the answer is not combining a set of bylaws that's been based on everyone else's suggestions, because they haven't been put through that filter. And most of the time, the result we see you end up with includes 50 or 60 bylaws, 20 of which might be relevant, and then another group that probably are never going to be able to be enforced, and then a whole bunch of invalid bylaws. And all that does is make it harder for owners to understand what their actual obligations are, because you have to find them in a fine-tooth comb. And secondly, the CMS has a whole bunch of bylaws that it shouldn't in the first place. So just picking up bylaws because another scheme put it in there and trying to come with a really big consolidated set that's going to deal with every possible issue ends up in a really poor outcome. So before a bylaw is even considered, it should be put through those filters of section 169 and 180 that we just discussed, and making sure that we're not trying to replicate issues or address things that are already dealt with in the legislation. And the reason we want to keep that out of the CMS is because if it's in the legislation, you don't need to put it in the bylaws. And if you put it in the bylaws and it's not exactly consistent with what the legislation says, which can change from time to time, as we learnt from the first example of section 180, it's invalid. And then all you're doing is creating bulk and volume to your CMS for an invalid bylaw. So that's to me, that's a pretty poor result. So let's say we've put our new bylaws through the filter of 169 and 180, and we tick all the boxes and we've got this great set of bylaws. It's not up to the committee to adopt it. So if the committee adopted it, they'd only be house rules. So what needs to happen is it goes to a general meeting considered by all the owners, and to be approved, it needs a special resolution. So that's not just a couple of owners voting for it. You need, of those who vote, at least 2/3. And then there's some tricks with counting the no votes to make sure that it doesn't disqualify the motion. So it's quite a a high resolution in relative terms. So once the special resolution is passed, someone needs to draft a new CMS, and it's an entirely new document. So the whole CMS schedules A to E get redrafted. A lot of it won't change, except Schedule C is obviously going to be different. And that whole document gets re-signed by the committee and then lodged at the titles office. So it's a little bit unlike other titles office documents like leases or building management statements, where you don't need to redraft the whole thing. You just draft what the changes are, and then it gets sort of attached as an annexure to the existing documents. But for a CMS, you have to go from the beginning. Didn't used to be like that under BUGTA, but that's how it is now. And that's why when you ask for your CMS, it might not be the current one might not be what you were given with at the beginning, because it's replaced from time to time. More of a practical point is that when you are lodging your CMS with the titles office, you will commonly have exclusive use plans. So the issue here is, even if you're not adjusting the exclusive use plans or making any changes, if they're a little bit old or blurry or don't meet the current requirements, the title office won't accept the new CMS and the new bylaws. And there'll be a little bit of mucking around to try and solve that issue. And it can be a little bit more expensive than even having a lawyer draft the bylaws to get a surveyor out to redraw the plans. A lot of the time we can try and massage it through by getting the original surveyor to do an update or send through the original files, because normally what happens is, because they're scanned and rescanned, they just get a little bit blurry over time. But unfortunately, sometimes the hardest issue in a bylaw change can be satisfying the titles office of the clarity of a plan that's unrelated. So it can sometimes be a little bit of a check early on if the committee's not sure about whether they want to go down the path, to see if they can solve this exclusive use issue first, because you don't want to make a one-line change to a CMS that costs $500 and then have to spend $5,000 on new exclusive use plans. So that's just something to keep in mind. So once we've got our great new bylaws, they've been through the filter, title office is happy with them and registered them, and exclusive use plans haven't caused any issue. And there are then bylaw contraventions. And this is where the body corporate's obligation under the legislation to enforce bylaws comes into play. So relatively recent decision that got quite a lot of airtime beginning of 2021 was end of 2021, beginning 22, was this Artigue decision. Now what happened there was bylaw contraventions. The lot owner who didn't like the bylaw contraventions complained to the committee. The committee said there wasn't much they can do, and they just sort of left it with the lot owner to go and take action to enforce the bylaws. And we go through that process a little bit later. But what that decision really crystallised is that the legislation says that the committee must enforce bylaws. So it can't just ignore clear bylaw contraventions. So the two obligations the committee needs to balance is enforcing them and acting reasonably. So that sometimes comes into play if there are, let's say, 5 people contravening the same bylaw in the exact same way, and the committee chooses to just enforce it against one person rather than the other 4. The answer isn't don't enforce against anyone. The answer is enforce it against all 5. So once you're enforcing, the committee needs to take that action. Yes, it's probably going to cost them some money, but unfortunately that's the cost of being a body corporate, and that's your statutory obligation. So as I mentioned earlier on, the process does work. It can take time, but if you follow the process, it will work. The biggest shortcoming is trying to shortcut it and get right to a result too early on. So step 1 is to issue a contravention notice, and this is can be your Form 10 or your Form 11, but it doesn't need to be. You don't actually need to use those forms. There's some mandatory requirements of what you need to send in a contravention notice, but you don't need the form. So continuing contravention notice is obviously if things are ongoing, someone's carried out some unauthorised works, and we need to make sure that they obtain approval for that or revert those works. Second one is for future contraventions. So these are the intermittent ones that aren't constant. So they happen for a little bit and then they're remedied and they happen again and then it's gone. So car parking is obviously, car parking on common property is a common one. Noise complaints, obviously another very common one. So when the contravention notice is sent, it has to be sent to the person who we think is breaching the bylaws. And if they're a tenant, we also need to send it to the owner so that the owner is aware of that contravention in their lot. Now, there's a bit of confusion here in the industry about whether the bylaws can be then enforced against the owner, and the answer is they can't. The owner is not responsible for their tenant's conduct, but the purpose of this is to let the owner know that their tenant is breaching the bylaws, because they may then be able to take separate enforcement action under their tenancy agreement. They're not obliged to do that, but they may want to do it if they might be having other issues. This just gives them notice of what's going on. So as I said before, there's no specific format. There are templates, Form 10 and 11 from the Commissioner's Office that you can use that sort of guide what needs to be in the notice. So a little bit of a checklist of what a contravention notice needs to have. So obviously we want to check off before we send it that it is an enforceable bylaw. We put it through our filter of 169 and 180. The committee has to authorise taking the bylaw enforcement action, so we want to pass a VOC for the committee. We have our general reasonable test to make sure that if we were to enforce this bylaw, we won't be acting unreasonably. And then we've got to make sure that there's an actual contravention going on, so that we've got a genuine reason to take the bylaw enforcement action. So hopefully we've got evidence or photos or logs or reports of what the issue is, and that any Form 1 that's been submitted gives us a bit of detail that the committee can actually do something about. So the notice itself needs to say the following things. Obviously, it needs to specifically say the body corporate believes they have breached a bylaw. They need to extract a copy of the bylaw and show the person that has been complained against what the bylaw is. We need to have sufficient detail to identify the contravention. So that's where the evidence standard comes in. And then depending on whether it's a continuing or a future contravention notice, you need to give them the period in which they need to remedy it, or the notice that they must not repeat the contravention. And that will apply for a future contravention for 3 months, or a shorter period if you state that. And then the important part is that it needs to have a final statement that if they don't comply with the notice, the contravention notice, the body corporate can take further steps to enforce it in either the Commissioner's Office or the Magistrate's Court. So the next step is to enforce it either in those two forums. The most common one is going to be Commissioner's Office, which is conciliation as the first step. This is probably the first point about where people try and shortcut the process and go wrong and try and go straight to adjudication. You can go straight to adjudication in some very, very limited circumstances. So 99 times out of 100, you'll be put through conciliation. So think of it as mandatory. Process involves filling out another form, which is a dispute resolution application form, and submitting it to the Commissioner's Office. And then they will effectively schedule a conciliation session. They've got a pretty good strike rate at this point. The conciliators know what they're doing. They'll explain to the person breaching the bylaws the process and the risks if they continue to do it. And normally you'll end up with hopefully a conciliation agreement that sets out what the person breaching the bylaws agrees to do. So to get that sort of result, evidence is really the key factor here. That conciliation agreement is not going to be enforceable unless everyone agrees to that at the conciliation. So if a body corporate does reach a really helpful result and they want to make sure it gets locked in, they've got to make sure it gets converted to an adjudicator's consent order. And normally you have to ask for that at the time. You can't sort of come back a couple of days later and ask for it. So that's a little bit of a tip there that doesn't always get actioned on. So if you don't have that consent order, the conciliation agreement's unenforceable and won't make too much difference. It's sort of an in-principle type thing. So instead of Commissioner's Office, we can go to the Magistrate's Court, and that's to impose a fine for breaching the contravention notice. Typically, it's not the preferred option. Magistrates sometimes don't like the court being used for bylaw enforcement when there is a Commissioner's Office there that's kind of set up to deal with this. Sometimes it's a little bit more worthwhile looking at, depending on the seriousness of the breach, timeframes with Commissioner's Office. If that's taken a little bit long, this can be another option. But to keep in mind it's going to be more expensive. It will probably be faster. So if it's a really important issue, it's something that you may want to consider. But it is a little bit more of a risk with that last point, with the approach the court might take. Following the conciliation, if it's not successful or your conciliation agreement is breached because it's not binding, the next step is to go to adjudication. So it's a similar type application form, similar type submissions that you put in the form, but it's a little bit different approach. You're asking for an adjudicator to make an order rather than for an agreement to be reached. So you've got to put a bit more thought into the submissions, the detail, the evidence, and the legal arguments around it. It's all going to fall down if the contravention notice is not valid. So making sure that contravention notice was properly issued at the beginning, at the time, without shortcutting it, is going to start to pay dividends at this point. So two things is making sure that the evidence is properly documented as well. Process does vary. I've got a very broad number there, 3 to 18 months, can be even quicker if it's an urgent issue. Other than the court, there is not an alternative. So we can't go taking self-help remedies. They don't work. That's when applicant is successful against the committee. So this is the process to go through. Be patient. You will eventually get there. And once you get there, you will get an order from an adjudicator. That's normally all you need, because the consequences of not complying with that order are serious. There's really big fines, in the vicinity of $50,000 as a maximum, because you're no longer talking about whether or not the bylaws are being breached. You're talking about breaching an order from an adjudicator. So it's almost like contempt of court. It's quite a serious offence. So that's all, I guess, from the body corporate's obligation in terms of enforcement. And I mentioned earlier that, particularly with that Arctic example, what happens if the owner wants to take the enforcement action and the body corporate is not taking their action? So the complaint form to send to the committee that you think someone is breaching the bylaws is called a Form 1 from the Commissioner's Office. It's effectively a complaint to the committee. So it doesn't get issued to the person you think is breaching the bylaws. It gets issued from you to the committee, and it's basically a request for the committee to take bylaw enforcement action. That should be all you need to do, but then it's up to the committee to make a decision about whether it is going to take enforcement action. So if they don't, you've got basically two angles to take. One is to force the body corporate to comply with its obligation to enforce the bylaws, or, which is I think sometimes a bit more practical, you are then able to effectively enforce the bylaws on behalf of the body corporate because they're failing to do it. So depending on what approach the owner wants to take, they're the two options available, but neither of those two options exist until you send the body corporate a Form 1 and until the body corporate does not take action within a certain time frame. So again, can't shortcut the process, can't go to either of those two solutions until you send the body corporate a Form 1 and give them the opportunity to take enforcement action. So this is the flowchart, which looks a little more complicated than it actually is. And you can actually download the whole practice direction from the Commissioner's Office. It's number 6 on their website. But this sort of breaks down the process, what we just spoke through, in a bit more of a visual way. So I know Nikki's going to send this out afterwards, but you can also take another copy of this from the Commissioner's Office. And the link for that is this first one here. And then I've also linked some other bylaw-related articles that we have published in the last couple of years.
Excellent. Thank you so much, Todd.
No problems.
Wonderful. We had lots of questions. So the first one we might cover is we have a bylaw stating work cannot be done to the gardens without committee approval, and also that approval is required before residents can keep a pet. However, our scheme does not have a manager on site and the committee lets residents do what they want. The common area gardens are a mess with half completed projects, and we have many unapproved pets at the property. Generally, my concern is that the bylaws are not enforced. Only one committee member lives in the scheme and they're not interested in enforcing the bylaws. So as an owner, I know I can submit a motion to change the bylaws or introduce a new one, but if the committee will not enforce the bylaws, what's the point?
Yeah, I think here looking at changing the bylaws might not be the best solution. You might already have the right bylaws in place to regulate the conduct that we're taking issue with. I think the best process or the best suggestion here would be to submit a Form 1, document all the breaches, put it all together in a nice little package for the committee and send it to the committee. And that will trigger their statutory obligation to take bylaw enforcement action. And then if they don't, you've got your rights to either progress it to force the committee to do it or to take the action against the people breaching the bylaws themselves. So rather than changing the bylaws, I think you'd want to send your Form 1 to the committee.
And is it worthwhile in that situation, Todd, to advise them to try and get on the committee and become a committee member if they have concerns?
Yeah, if you're not, I suppose, participating in the decision making and you don't like the way the decision making is taking place, and that's absolutely always a good suggestion. Yep.
Okay, another question we had come in. Our resort complex has 83 residential apartments and 2 commercial lots. We're in a community title scheme and we're under the accommodation module. There are 11 resident owners and 6 of these have dogs. An interstate owner visited the complex recently and complained to our chairperson about dogs on common property, and this led to a vote that all dogs be muzzled and carried when on common property. Owners with dogs think this amendment is unreasonable. No dogs have been a problem in the past, and we feel it has been an overreaction to something that may or may not happen. The majority of the residents with dogs are aged over 70 and could not carry their dog or a dog crate. And when we purchased our property, we all got permission to have our dogs on site, and we would not have considered buying a property here if the bylaw had been in place. So what options do we have?
Yeah, that's an interesting one, because I suppose the question there is the committee imposing this as a house rule? Because if they are, then it's not enforceable against those dog owners. I think if they were to change the conditions of approval on an existing pet, or were to change the bylaws that regulate how pets are allowed on common property, it then comes down to the catch-all of reasonableness. And there's been a number of adjudicators that talk about whether muzzling dogs as a mandatory requirement is reasonable. Obviously, as I said before, it's circumstantial, but to satisfy the circumstances of being reasonable, there needs to be some justification for that condition. A dog's existence on the common property does not meet that. There needs to be a reason for that dog to be muzzled. And that's just not because it could do something. It's because it's got some sort of evidenced propensity to do something, or it has done something. So if there hasn't been an issue for years, I would say that would be an unreasonable condition, and sounds like it's probably unenforceable. If they do try and put it up to a vote at general meeting, it sounds like there might be enough owners to vote against it and stop it from a special resolution passing. So that's probably how I'd approach that one.
Okay, and we had a few questions about the enforcement process and the valid bylaws. So if you're in a situation where you're a resident and you've received a breach notice and you believe that the bylaw, that the notice has been served on you, is not a valid bylaw, what process would you take in that situation?
Yeah, you'd want to formally respond to the contravention notice, and you'd want to set out in writing back to the committee why you adopt that position. Because what should happen is that if and when a conciliation application is made, that needs to be considered by the conciliator as well. You would want to hope that if you were correct and you've set that out to the committee, that they take note of it and address that before they were to make a conciliation application.
Okay, thank you. And we might just try and fit one other quick one in. I'd like to ask this because we get asked this question quite a bit, and it's to do with caretakers enforcing bylaws. So as our caretaker is a non-voting committee member, is he also responsible for the enforcement of bylaws?
Absolutely not. So, yeah, you're right. It's a very, very commonly asked question. The reason it's asked, I guess, is because as an on-site manager, they're seen to deal with all the issues on site, but that's not the case. So there's a number of decisions, specialist adjudicators on it, that talk about this obligation of the committee is to enforce the bylaws, and those obligations can't be delegated. So even if the management rights agreement talks about a manager's obligation to enforce bylaws, it's limited to really providing some level of administrative assistance to the committee. So that could be, we might ask them to go and take some photos of a particular car that keeps parking somewhere so that the committee can take the enforcement action. but there's no power or ability or anything more than assistance that the caretaker can give to the committee.
Wonderful, thank you. All right, well, unfortunately, we will have to wrap it up there and leave it at that. Thank you so much, Todd, for joining us today. It was great to have you back again. You always give such clear information, and I think some people have already popped some comments in there to say thank you very much. It was a really great session.
Thank you, Nikki.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.